I want to introduce you to Julian Lambert, who is the General Manager in Victoria of Law and Order. So Law and Order do a great number of things, and actually I'm going to get Julian to talk about what those things are, particularly in the context of the evolution for basically starting off as providing litigation services, support services, whatever that means, which I think when I was a girl usually meant doing the really full-on photocopying, through to a very, very much changing environment today. And you don't just do litigation support now either. No. I mean, it's transaction support really, isn't it, as well?
That's right.
So one of the reasons that I asked Julian to speak there are two key reasons. One is I went to a presentation some time ago now at the LIV that was given by one of his colleagues, talking about the work that his company did with Bushfires Royal Commission and the bringing of technology into the courtroom. But also then Julian and I had the opportunity to have a couple of chats along the way, and he and I share a common interest in what the future of law looks like, particularly for you guys. And from my point of view, the one thing I can say for absolute sure about what the future of the profession looks like for you is fundamentally different from what it looked like for me. And I find that a really kind of interesting thing. I know I spent a long time in the first couple of years in my career basically doing due diligence exercises, reading huge numbers of documents and trying to work out what they meant as people were buying and selling. In fact, funny story, sometimes we were trying to find out what was the single source of truth, which was the correct document. And I remember having two documents, and we were sitting there, two people, each of us reading to see if they were different from each other. And I got this idea, because they were, it was pretty easy to unpick them, of actually just holding them both up to a window with the light behind it, so that if we put both pages on top of each other, if there were differences, they would have shown up. And so you actually could do that really quickly. We didn't have to read the documents. And I had a partner in that law firm call me a stupid C word, which actually sent me marching down Macquarie Street so angry. And it was a different place, different time, different profession in a whole lot. I didn't think that was a stupid thing to do at all, and I still don't. It was just actually using technology, sunlight, in order to compare things, because that was what the task involved. And I didn't want, and I certainly don't want you guys to be spending, your enormous intellectual powers just comparing documents for the sake of seeing if they're different, not why they're different or how they're different. So I very much see changes in technology, and the ability now to OCR, use optical character recognition, and compare those documents and see in a heartbeat. Nobody these days would do what I had to do back then. And nobody would think you were stupid for using technology for doing it either. But I see this as an opportunity, that there's this time of rapid change is real opportunity for you guys, particularly people, I did an LLB. You guys come with undergraduate degrees. Most of you have working industry knowledge. That means that you can take that, plus the training that you do at law school, to actually do a much better job than I ever did in the first 5 years of my life. And possibly once you're 5 years in, you'll do a better job than I've ever done. And I think that's a good thing. So, and I think Julian and I see this the same way. We see change as opportunity. There are plenty of lawyers who will see it as threat. And so I want you to be thinking about the way that technology is changing and how that will impact your life as professionals, because you're the ones who will go in not frightened of that and be thinking about what can be done, and that will make you better and more useful practitioners as well. So I'm going to hand over to Julian. Julian has agreed to be recorded. His slides will be available, not nearly as precious as the lawyers and the judges that we deal with. But even so, I've also told Julian that we've got the Go soapbox. He's going to present for a little while. We won't have questions during the presentation, but we'll have plenty of time for a robust discussion afterwards. Still use Go soapbox if that's the way you feel most comfortable doing it. Got to say, last time around, the Go Soapbox questions were absolutely excellent. I'm glad I'm getting a little bit of thinking music time to answer them, and Zoe is too. So I'll hand over to Julian and take my seat. So
thanks, Kath.
I'd like my phone to come.
Thank you very much, Kath, for having me along, and thank you all for coming. I know you probably feel like you have to be here anyway, but when I was at uni, I wasn't always there. So seriously, thank you very much. I feel really privileged, actually. I'm just accustomed to speaking to groups of lawyers in the comfort zone, their comfort zone, which is their own law firm environment, and they lay on lunch. Sometimes they feed me, sometimes they don't.
I'm sorry you're not getting fed today.
Yeah, no, and that's totally cool. No, I guess I'm talking about the fact more that, you know, you're not always made to feel welcome in a law firm environment. Chatham House rules in here, great. Because I'll try and make this as interesting as I can for you and not be an adjunct to the slides that I'll be showing you. So I'll be giving you anecdotes along the way. I'll leave the names out of it to protect the guilty, and you can make of it what you will. So this is the slide deck that I actually take to law firms, and they have me along, which is something I've been doing for years. I really enjoy it. And I learn an enormous amount from it, and I reckon I'm going to learn more today than I probably have in the last half dozen CPDs that I've done at law firms. I've just got that feeling. And that's part of my motivation for doing this, is so I can find out exactly what's in your heads as students of the law. Because I think I know what's going on inside the heads of the profession, because I'm lucky at Law and Order, because of the nature of our business. I deal with, we've got 2,000 clients, ranging from sole practitioners in Box Hill through to the federal government, large government agencies, and everything in between. Top tier law firms, mid tiers, some of which are struggling. International firms that are just moving into this country now. White & Case, in fact, opens up in a couple of weeks. Look them up; they're an enormous law firm. Pinsent Masons is construction specialists, among other things. They opened up about a year ago. They're going quite well. So it's a really interesting time in the legal marketplace. And I talk about disruption. Kath's already flagged that with you. I would imagine that you've already sort of heard that word probably too much. It is hackneyed, but I guess it informs what's going on. So I've been in the profession not as a lawyer, but as a litigation support or legal technology person for 25 years or something ridiculous. Dad was a lawyer. I know lots of lawyers. I love lawyers, I love the law. I don't know what it is, it's in the blood. There are other lawyers and politicians and stuff in the family, I guess it's in the blood, I can't change that. My best mate's a barrister, he drives me nuts, I drive him nuts, and you'll see why soon. So just really quickly, this is what I'm going to run through today. ESI, does anyone know what ESI stands for in this context? Anyone want to have a crack? Electronically stored information, that's all it is. Anything that's stored on a device, in the cloud, wherever it may be, and it's electronic. It could be a scanned hard copy document, for example. And eDiscovery, has anyone heard that expression or term before? eDiscovery, there's a few nodding heads, there's a lot. Good. Electronic discovery, eDiscovery for short. Some of the legal framework around that. Now, I'm not going to sort of do a deep dive into any case law or legislation or anything like that. I'll probably go into a little bit of the court practice note, one court practice note in particular that speaks to this. E-courts, electronic hearings or electronic trials, electronic arbitrations, electronic anything involving the need to get people together for a legal related purpose and disseminate that information online or in some other way using technology. And then I'm going to go to emerging technology and trends, just to finish off. So, look, the point of putting this slide up is to show you that Law and Order reflects, my company reflects the current status of the legal profession when it comes to managing information. So we do an insane amount of photocopying, printing and scanning. Photocopying and printing in particular, it's insane. Right? The owners of the business do quite well out of those two service lines alone, but we have 10 service lines. We do e-courts, we do e-discovery, we do consulting, we do photocopying, printing, scanning, court books, appeal books. The list goes on. So it's a lot of different service lines, but a lot of them use technology, pardon me, to print stuff out. Be it a whacking great photocopying machine that sort of goes from there to there in size, quite literally. It's a huge monster. We've got about 10 of them. Through to a stand-up device. It's about this big. We've got 4 of those that do high-volume scanning. So we do prodigious amounts of printing and photocopying of stuff that is often native electronic documents. So it's electronically stored information. So kind of, I'm hinting fairly strongly here, hopefully you're picking up that the fact that lawyers don't want to use technology a lot of the time, and I print it out, okay? Drives me a bit nuts, but it's lucrative. I'll do it. Cool, no problem. That's fine. Look, you know, we're all over the place. We're in 4 capital cities. We're in Singapore. I'm going there next week, actually. That's a tough market. We started there a couple of years ago. But it's an arbitration hub, and there's a lot of sort of latent potential there as far as using technology. There's a lot of talk in the government here and in Singapore about using technology to affect better outcomes for the community and as a social justice welfare kind of conversation. It's just not done enough. It's just not done. Anyway, so there's a bit of wallpaper, a bit of background for you on law and order. Pardon me. So to start off with, I guess the big topic, electronic discovery. Well, there's the problem, right? And we often see this, that there's just an enormous volume of material floating around these days. I mean, we all use email. I would imagine you all use Facebook. Who uses Facebook? LinkedIn. Okay. Pinterest. It's usually a female thing, and so it is in this room. My partner uses Pinterest, yeah. And I'm not saying it should be, by the way, it just normally is. Is anyone wearing a Fitbit or other mobile device? Yeah? Good. Okay, there's plenty in this room. I normally get one, and I pick on that person because there's only one. I normally just pick on that person when I go to law firms. So this is the thing, right? All of those devices and all those platforms, they're conduits. They're ways of storing and sending information. And they're so easy to use these days. It's ridiculous. So just to throw a couple of stats at you, 112 billion business emails allegedly are sent each day globally. I'm not that surprised at that. It's probably more, who knows. Facebook, if it were a country, Facebook users would comprise the 3rd largest country in the world. That's remarkable. And so the problem for litigators in particular is not just litigators, but normally litigators who need to participate in discovery and be seen to be doing the right thing and follow a whole lot of procedural rules and be model litigants in the government context. They've got a real task ahead of them in a big fight in particular, but not always in a big fight, but just where there's a lot of information. So they then have to find out ways, and they need to have a framework with which to go out and collect everything and bring it in, and then they need to start to look at it. So back in the olden days when I was working in the photocopy room at Minter Ellison, which by the way I worked in the fax room as well, they literally had a fax room at Minter Ellison in the early 90s, that was fun. I'm
older than you. My firm started.
Not
the
by much.
firm I was in had telex.
Telex, yeah. Well, actually I worked at Ellison Hewis and Whitehead in 87, and there was a telex going on there, which was mystifying. It still is.
I don't think you have to be that old. I started in the fax room. And
Right.
I'm
There you go. Okay. Well,
Lawyers still use faxes because you can deem a receipt from it, you can deem it served.
Yes.
We get faxes from solicitors all the time.
Yes.
We get the email backup as well. We get a digital file, but they send a fax to back it up so they can tell that they've sent it.
That's true. That's true. I've got one client left that uses a fax, and I want to strangle him sometimes. But that's another story. So all this collection of data, it doesn't necessarily mean that lawyers these days need to spend more time reviewing it, and that their clients need to spend more money paying the lawyers to review it, because that's the most expensive part in this whole process of electronic discovery. You know, there's thinking about where all the stuff is, there's locating it, gathering it all together, putting it on something, giving it to lawyers to look at. And that's where the rubber hits the road, is the lawyer's time, in terms of me as a client paying my lawyer to do a job for me. That's the expensive part, is lawyers' time to look at that stuff. So have a think about that as I go forward, because I'm really big on saying to lawyers, you know, you guys, you're not always putting your client at the centre of your decision-making processes when you're determining how to do something in an electronic discovery context. E.g., ringing me up and saying, Julian, that 8 gigabyte USB I gave you that's full of native electronic documents, including spreadsheets that need to be formatted before they're printed, I want you to print it all out. And I say, so what's this actually for? And they say, it's for discovery. Okay, well, I can put it on a database so you can start looking at it tonight, or I can give it back to you in 10 days' time once it's all done, and you can start to then go through it in folders and folders and folders of documents. And they say, that's cool, I understand that. Intellectually, I get the argument. Emotionally, I'm not ready. Print it out. Right? I'm editorialising, but that's the thought process. Still, that's kind of a bit of malpractice for me. Maybe I'm a harsh judge. You know, I guess I'm labouring the point now a little bit. The digital universe, it's doubling in size every 2 years. So we're just creating more and more and more dramas for ourselves. So our technology tools need to get smarter and smarter and smarter. And therefore we, as users of the technology, and my team as administrators of the tools, need to get much, much better and have far more willingness to engage with those tools and those processes that make this possible to manage. Okay, enough with the statistics. So there's a dictionary definition. I won't read that, I'll let you just absorb that. A definition of electronic discovery. Okay, I think it's fairly self-explanatory. It's just a process of finding stuff, pulling it together, preparing it or processing in certain ways to enable lawyers to look at it and make decisions about it in order to fight the fight for their client who's paying them to do that. So these days what I see still, pardon me, because of where we're at I guess in history, the evolution of technology, I still see floppy disks and CDs that are scratched up and DVDs and hard drives, all sorts of media, all sorts of file types, some of which are somewhat challenging. We have to password crack to get into, some that, like CAD drawings come to mind, and other construction formats that are not just sort of sitting on everyone's desktop as part of the Microsoft suite, that needs special software in order to get to them and view them. And then of course there's good old paper. There's still plenty of that floating around. It's funny though, this is the 4th year I've been at Law and Order. It's the first year I haven't been getting, you know, so-and-so from top-tier law firm ringing me and saying, I've got 20 boxes of documents that need to be scanned, delimited. That means separating each individual document so you can determine whether it's a parent document or an attachment document, because that relationship's sometimes important. I need them OCR'd so I can search on the scanned image. I need them numbered, every single page on the digital version. And then I need you to capture manually the description of the document, the from, to, author, receiver, date, so I can then prepare a discovery list and give that to my opponent and the court. That takes a long time for 20 boxes. It can take us up to 2 weeks, depending on how many individual documents there are. And we charge $1.20 per document to do the objective coding. That's the manual task of sitting there. Once the document's scanned and somebody looks at it in Sydney, in our Sydney office, and goes, date, there it is. From, oh, there it is. And you can imagine, right, because each document's different in correspondence files and the like, it's not a fast process, and it's prone to error, and it's expensive, but we still have to do it. Okay, there we go. We put it into a platform. Don't worry too much about the names, just think about the fact that it's a platform for lawyers to access like any other online platform, username, password, it's secure, and then they can start looking at stuff and going, relevant, yes, no, related to these issues that Julian's team has set up for me already. I'll allocate them to issues 1, 5 and 5.3. Right? It's a fairly basic standard litigation review task, but the scale, you know, in terms of the size of information, the type of information that needs to be pulled together, disseminated and made available to lawyers, it's not always a straightforward task. It takes a bit of time. So there's this great workflow that's been designed by a bunch of lawyers and IT or legal IT people in the US a few years ago. arising out of a conference called the Sedona Conference, when they got together in the US because it was just an imperative, because there's so much volume involved in litigation over there, as you can imagine. It's a litigious society, the volume's huge, the cost was high, and still is a lot of the time. So these people got together and said, geez, we need a standard, this is doing my head in. We need to have some standard methodology that we can work by ourselves as lawyers and explain to our clients, so our clients understand where they are in this workflow and where we are and why things are the way they are. And the idea is, with this workflow, it's called the EDRM, the Electronic Discovery Reference Model. Look it up, there's a good website on it and they've got other standards, but this is the core one. You don't need to sort of have a massive command of it, you just need to know it exists and that it's designed as a conceptual framework for doing discovery in 2016 globally. So the idea is that on the left-hand side, you start left and you work your way right. It's not always a linear process. Often you'll go, oh, hang on a second, my client, I'm started to analyse stuff, my client's actually coughed up another terabyte of data, and we need to process that and get that in here and run more keyword searches and whatever. So the volume of material, be it hard copy or native electronic, is often high over this side. And the idea is that as you work left to right, the volume's coming down dramatically. That's the key, is dramatically. The reason we want to dramatically reduce the volume is because before we give anything to the lawyers to start looking at, we want to make sure that it's a much more manageable volume of material, because the lawyer's time costs the most in this process. So we need to contain that cost. That's part of my job, is to contain the cost for your client and for your firm, or whoever you work for, yourself, if you're a sole practitioner working for yourself. We need to keep that cost down.
So
Yeah.
do you go out to a public tender for your services?
Sometimes, yeah. Yeah, I'll come to that later on. What I want to do is keep the questions to the end if I can, and then we'll deal with that separately, because what I find is that often the questions are answered throughout the course of the subsequent slides. All right, so information governance, that's really relying upon your client to have done a good job at managing their own information. They won't have always done that. In fact, they rarely do, right? Unless they're, I don't know, British Petroleum or somebody like that, a bank maybe, where they've got a good, strong in-house, well-maintained document management system for all their corporate records. Some organisations now, the big ones, the multinationals, they litigate all the time, and so they prepare themselves for that in lieu of receiving a writ. So they set up litigation holds as part of their IT environment for managing their documentation. And then, you know, a writ comes in, something happens, someone's subpoenaed, or a Royal Commission sends a notice and says, you've got to produce this stuff. I'm prescribing what you need to send. Sometimes it's more prescriptive than others. And then they go about looking for stuff with the lawyer's help, ideally. Then it's collected, sometimes forensically, in order to not disturb the integrity of the document, so not to change the date or any other metadata property in the document. Not always. We often deal with the IT people at the client end. So I've got my law firm client saying to me, you know, finance company such and such in Hawthorne needs to, you know, find all these records. They reckon they've got an email server and they want to give it to you. You know, okay, hang on a second. Who are the persons of interest in this case? Which custodians, which email custodians do you want to focus on? So we're trying to sort of do that. So I talk to the IT people. And then once we've got everything that we think is the scope, hard copy and electronic material, we then start processing it. So one of the key processes, just off the top, that removes a lot of volume straight away is deduplication. So it's a technical process. It's a little bit like DNA matching documents, and you can do it with electronic documents. It's called MD5 hash, relies on an algorithm called MD5 hash. You can argue that one in court, and it's a bit of a standard these days, or it is a standard, and you can very quickly reduce your volume by half just by removing duplication. And then lawyers normally set about keyword searches. So my team says to the lawyers, you know, what's important, what are you looking for? What date ranges do you want to use to restrict the volume of material? And they normally have a feel for that. They work with their client, they come up with a keyword search methodology. We run that over the data, and again, reduces the volume down. Then when we think we've got to the stage we're about ready to go, we'll start putting documents into the online platform I talked about, so lawyers can start looking at each individual document and determining whether it's relevant, yes, no, discoverable, yes, privileged, no, what type of privilege status does it need to carry, all of these sorts of things. We build them into the database. So all the knowledge then, the lawyer's knowledge about the material is going into the one central repository that the law firm can collaborate on with their client, with counsel, with witnesses, whoever else. It's a fairly simple concept, not done often enough though. And then there's production. So that could be an electronic brief, a court book, an appeal book if you're in an appeal stage, and of course the discovery list can be produced from there. And then you go, as a very low number of cases do, to court, and we can present that information in court electronically. Right. So I've dealt with all that, pretty much. Right. So this is important, I reckon. The legal framework, in terms of not being a lawyer, which as I said I'm not, I think of the legal framework almost exclusively in these terms, because this is the screwdriver and the spanner that lawyers use, other than outside the technology, to do electronic discovery, or any discovery really if they want to. So all of these practice notes attempt to provide the profession with a framework to do everything from number documents through to tell them what sort of information to look for and capture, through to how to exchange discovery electronically with your opponent, through to talking about how here's a contact name and number for somebody in Victoria or New South Wales, wherever, if you want to use technology in a hearing. And they talk about early meet and confer conferences, case conferences, to get together with your opponent, and how they encourage the profession to do that, which is really good. Pardon me. And you can see on the right-hand side, the Federal Court of Australia just 2 weeks ago released the first update in 9 years to its technology practice note. It shows how slow they move. But they did it, good on them. And it's a deliberately low threshold, so less than 200 documents between the parties. So that's roughly, let's say, 2 lever arch folders of documents, and the averages that my company uses. That's really low. It's a little bit meaningless though, because lawyers, at the moment, a lot of them don't see any value in spending money on using a database for anything less than 10, even 20 folders of documents, right? And there are historical reasons for that I won't bore you with. It was basically the fact that technology was only seen to have a place in helping discovery in a mega matter, where there's lots of documents and a lot at stake, lots of parties, and they want to beat each other up and flex their technology muscles and win on that side of things. The practice notes attempted to change that, but they've failed. That's my personal view, not the views of Law and Order. My personal views, they've failed because they're guidance notes, they're practice guidelines. Right? They're not hard and fast rules in the way that some of the American rules are, that say competence in a lawyer is part defined by whether or not they know how to use technology. That's what the practice rules in the US say as of 2012. Doesn't say anything like that here. Everyone's a little bit too frightened to upset the profession. I think that's a part of the problem. However, the practice notes are used, and litigators, more experienced litigators, know that there is a practice note in the Supreme Court of Victoria or in the Federal Court or New South Wales, whatever. They know that there's a practice note that they can lay their hands on and that they can use, if they're smart, I reckon, they can use as a bit of a tactical advantage to their opponent to say, hey, I've been using the practice note to actually organise my discovery. Have you? Because I'm going to exchange my discovery with you, and I'm going to go to the directions hearing or one of the preliminary hearings, and I'm going to tell the court that that's what I've been doing, and you've given me nothing because you didn't even know the practice note existed. So it's a really important sort of tactical tool, as much as I think it's a really good practice to use the practice notes. But I'm still quite surprised at how little some law firms know about these practice notes. Anyway, they've been around for a very long time. The first one came out in '98, so it's a pretty mature they're mature practice notes, the way they're drafted. Look, I'm not going to go over all of these, but I pulled these out in my slide because I suppose they're motherhood statements, some of them. But the purpose of the practice note is to facilitate the effective use of technology in the preparation for and at all stages of a proceeding, as well as to assist the party. So that's why it's there. It's meant to help. It's meant to make things more efficient, faster. Because they're practice notes, they're just, yeah, all right. I feel a bit disappointed about all that. The case law. I know Kath has sent around some case law. I called out these ones. I don't know, they spoke to me a little bit. The first one, just to point out, even though it's not Australian law, it's 1972, this stuff's been around. There's been case law around, probably earlier than that too. Inadvertently disclosing privileged documents is arguably easier because of the volume. I don't know, that's not what I've seen over the 20 odd years that I've been doing this. Inadvertent disclosure or discovery happens whether you've got hard copy, electronic, 100,000 documents or 1,000 documents, I don't know. If you've got the right QA processes or quality assurance processes in place, you should be okay. And the onus still rests with the lawyers, not the technology support people. The onus is still on the lawyers, in the insurance terms and everything else, to not disclose anything you don't want to disclose. And if you do, there's some case law to say that you can claw it back, which is comforting. For me, the most important ones, though, are these recent decisions on technology-assisted review. Has anybody heard of TAR, technology-assisted review, or computer-assisted review, or also known as predictive coding? Yeah? Cool. Do you want to come down and tell us? No, don't. So, this is amazing, I think. So we're getting much closer to the point where the Australian profession is going to issue something, and I've heard whispers of okay, it's another practice note, but something out of the Victorian Supreme Court that will start to prescribe some things about the way that this particular thing is going to be done. Does anyone use Pandora Radio? Yep. iTunes Genius. Good. Look, there's just so much artificial intelligence in our world already that we've been using for years that we don't even really think about as artificial intelligence. And it's just happening more and more and more as, you know, Facebook throws up particular, or used to anyway, throw up particular advertisements for things, and I think, how did it know that I like such and such jeans or music? Or it's collecting information about our preferences the whole time. So this has now been translated to the legal context where, particularly where you've got a huge number of documents. I'll give you an example in a sec. You can use the machine's learning ability, its algorithms, to learn from you and your decision-making processes when you're making decisions about documents, what's discoverable, what's not. And so we worked in a case where there was 6.6 million documents versus one lawyer who had less than 2 months to do discovery and was freaking out. And there is no Australian case law, there is no legislation on using this technique to make decisions about documents. So this was luckily, this was an international matter, and our client was an engineering company, and he just said, I'm one in-house lawyer, what the hell can I do? And we said, well, there's this thing, it's been okayed for use in the US. This is before it was approved in the UK and Ireland. It's called predictive coding, technology-assisted review. You review a seed set of 1,000 documents like you normally would, decide whether or not they're relevant, and the machine will watch you do that and learn from your decision-making. Then you give it 1,000 documents, and it runs its review automatically over the documents based on what it's learned from you. And then you check its work, you QA that work, Then you do another 1,000, it will watch you. Then you give it 1,000, and you do that back and forth 3 times, roughly 3 times normally. And then you say, you know what, I reckon we're ready to go. This machine's getting better results than I am. And you give it the rest of the review. And we hit go, and it does the legal review task. Wow, it's incredible, right? If you've got a lot of documents, and they're native electronic documents, they're pretty much the 2 criteria that you want. So the first case a few years ago, Judge Peck in New York said, you know what, I reckon we're okay to use this. And he must have been busting, by the way, because he spoke about it at a conference 4 or 5 months before he gave that judgment or handed down that decision. It was okay to use technology-assisted review. He said, I think someone's going to make orders about this soon. He turned out to be the guy that did it. He's a bit of a celebrity in legal technology circles. So that's where we are kind of right now when it comes to discovery and dealing with the biggest challenge of discovery. People are starting to use algorithms in some contexts. Okay, electronic courtrooms. Well, in 1997 I worked on a case called Estate Mortgage. It was a huge insurance stoush. It was $1 billion or more that was at stake. I worked with a guy named Julian, who I assume many of you will know or have heard of. Terrific guy, lovely man, and you wouldn't believe it, he's a tech whiz. He's an absolute tech whiz. He's a life member of the Victorian Society for Computers and the Law. He was getting me to run around between the hearing room and my law firm and his chambers to plug stuff in and, update real-time transcript and all sorts of things. It was the first time I'd seen technology in the legal profession on such a scale. It was a purpose-built hearing room. Almost every law firm in town, it seemed, was participating in this massive litigation, and we had evidence was being. This isn't a photo of that, by the way, but this will give you an idea of what we were looking at. That's the Royal Commission into Trade Unions that we worked on a few months ago, with Julia Gillard giving evidence that day. There was no webcasting, but it was all about showing the evidence electronically in the hearing room. And everyone had machines. And there was real-time transcript, and there was I think the court book was 700,000 documents, so that's a condensed version. You can imagine how much material there was after they sort of whittled everything down. And it was bloody expensive, right? So that's, 20 years ago? It was really expensive, but it worked. It worked because there was some really good workflow and Burnside was driving a lot of the, I guess he was kind of almost shaming people into daring them not to use the technology, right? And it worked. And 20 years later, doing electronic hearings is far cheaper. It doesn't require you to have a $1 billion litigation at stake. It uses wireless technology. We can webcast, as we do a lot of the time. We're doing the Child Abuse Royal Commission at the moment. We do the webcasting and done all the evidence presentation online and in the hearing room and the public gallery and the press room for that. We engage third-party transcript service providers. So it's a massive project. You can imagine as a lawyer, you don't want to be worrying about all that stuff. You wouldn't be able to get your work done. So that's kind of what we do. That's one of the big things we do these days, and that's where the profession's going now, is almost, it will, I think, get to the point where physical courtrooms won't necessarily be required. Be able to virtualise everything. And I saw Richard Susskind. Has anyone heard of Richard Susskind? Of course you have.
Sorry, I'm a groupie.
Great,
I'm
yeah.
a big time Richard Susskind.
Well, he's a very handsome man. I'm not
He's
surprised.
a very handsome man, actually.
But in all seriousness,
Very gorgeous Scottish accent as
yes, he's a very charming man, but a brilliant man. He's written, I don't know, maybe a dozen books by now. His most recent one he wrote with his son called The Future of the Professions.
well. Which I think should be mandatory reading, by the way, for
Yeah.
all of you.
Yeah, check it out. It's
Tomorrow's
great.
lawyers as well.
Legal practice management, a lot of this stuff's covered.
Right.
I know,
Cool.
I wrote that course, that's why you've got his
Right. That explains everything. So Susskind, one of the big things he's been talking about lately is the fact that we really shouldn't need to have to go to a courtroom. It's expensive. there's a whole lot of sort of time-consuming ceremony, and I don't know, is it conducive? Is it about the client? Again, I think, is it about the client, or is it about the court? Is it about the law? You know, the law is doubtless important, but there are sort of structural and a lot of other sort of physical dynamics at play that make it quite intimidating, and I know that's part of the idea, for those that participate in the court process. Is that about justice, or is it about the court? You can debate that forever. I've got my own views. Anyway, we do it. And it's getting cheaper and easier. So that's what, if you're a litigator, and you want to be a litigator, that's probably what you're going to be involved with. There's another one we've done. So that's our guy Jason, court operator. Every time evidence is called out, he hits a button that comes up on all the screens. It's not rocket science, it's the planning, it's the key. Weeks of planning sometimes. Okay. Has anybody read an article on artificial intelligence in the law lately? No? Okay. So Lawyers Weekly, does anyone know Lawyers Weekly? Yeah, you should have a look at Lawyers Weekly. To be honest, I think it's a bit of a rag. But, you know, it's not the Law Institute journal, but it's good because it gives you a decent snapshot of what's going on with some things. So artificial intelligence gets a mention at least once a week, or at least in one article a week in Lawyers Weekly. You know, I've never seen so much stuff on artificial intelligence as what I'm seeing now. So that seems to be another thing. There's a lot of theatre around it, I think, as well. A lot of law firms are kind of popping up and saying, oh, we're doing, you know, we've got a partnership with artificial intelligence company X, and we've developed this thing which is amazing and our clients love us for it. Yeah, I don't know. Why am I still printing zettabytes of data each year, you know, or each week? I don't know. I'm not seeing it yet. It hasn't got to the point where it's a big deal. It's a big deal in terms of the volume of reporting on it. It's not a big deal as far as delivering benefits to clients yet. But that will happen. It will happen. I honestly believe that. So there's a guy, just as an example of what's going on, there's all sorts of crazy things going on. There's a law student in the US, Stanford University student. This guy's 19 years old. He created, using a series of algorithms, he created this thing called Do Not Pay. It's a chat bot. So you chat with it as a user and you tell the bot, okay, I've got a parking fine in Swanson Street, in Burke Street, and these were the facts as I see them. Input all the information and it will spit out some advice on whether or not you should contest that parking fine. And the statistic was that it successfully contested $160,000 parking tickets in London and New York. Successfully. It's a 19-year-old using code and algorithms. Then there are other things. So I've talked about legal review or of technology-assisted review. That's artificial intelligence. It's using algorithms again to learn from human experts in order to mimic those decisions. And by the way, they inherit our biases, so that's just something to think about as well. So there's always a human element in these things. But contract review, there's a thing called Law Geeks, Law G-E-E-X, where the use of artificial intelligence insight comes from the tool's ability to compare contract documents to enormous databases of similar contracts to identify standard clauses and irregularities. So these machines are doing what our brain can't do at the same rate because of the processing power of computers is increasing exponentially each year. So it's not just the sort of smart mathematical side of algorithms and things, it's the sheer raw processing power, the processing of thoughts, if you like, that we can never ever match. So this technology reads the contract, understands it, and then contrasts it against what it has in its database, And the second step is that it segments contracts down to sections, clauses and keywords, and then it compares individual clauses in contracts to hundreds of examples to identify different features within them. I asked earlier too if there are Fitbits in the rooms, because in 2014 there was a Canadian case where a lady who was a personal trainer was injured, and the extent of her injury was challenged, so her Fitbit data was subpoenaed, and it actually showed that her mobility was, just on the face of the Fitbit data, was in fact severely impaired by the injury. So she won partly on the strength of her Fitbit data. So again, producing that sort of evidence, just to throw that one in there. All right, I'm done. Just going to finish on one last note that's a fact still, right? Most of my clients actually look like that. They behave like that. So what I'm getting at is that there's some really creative, brilliant people in the law. You know, I know I've ragged out lawyers a little bit here, but they are fantastic people. I love them. I told you already, my father was a lawyer, my best friend is a lawyer. If I didn't love lawyers and the law, I just wouldn't be hanging around in it. It's still about people. So I know I've talked a lot about machines and learning and algorithms and MD5 hash and whatever, but people develop those things and will continue to develop those things. And in terms of the people element, I just go back, I guess, to what I've said a couple of times already, is that put the client, which is a human being, not a bot, at the centre of your decision-making processes when you become lawyers. Because if that's your starting and guiding principle, you should be okay. Cool. Thank you.
I have a Hammond organ in my house.
Oh, really?
I personally think the Hammond
Fantastic.
is a very funky device.
It is.
So there are tons of really interesting questions on the soapbox, but it's all about the people. Do any of you want to lead off with any particular comments or observations?
So I was wondering if you had any sort of statistics or analysis about the accuracy between a computer algorithm scanning through documents and 4 or 5 junior associates scanning through documents and showing them to a partner or senior associate thing.
I can't pick a number out and give it to you, but I'm sure I could. I do know, though, that there's, anecdotally, the degree of accuracy with the machine is higher.
Can I give you an example that fascinated me? I saw a guy who's one of the technology council from Google speak earlier this year. It was out here for the ILTA conference. And Google have, this is in a patent review context, so Google buy up businesses all the time, and most of the businesses they buy will own patents. And when they buy the businesses, they're often trying to buy a particular patent for a particular thing, but then when they go and do something else, one of the things that they want to look at is, well, do we already have patents in our stable that might be interesting or useful in this new thing that we're developing? And they have terabytes worth of patent data. So they basically wrote a machine learning algorithm to review their patents for relevance for particular reasons. And they went through the sort of process that Julian was talking about. How they did that too, though, is they basically put patent specialists in a room and got each of them to review, I don't know what number, and I actually have the presentation, so I will find it and share it with you. But my memory is it's probably about 1,000 each, but the same 1,000 each. And roughly, I think it was around 75% of the time they agreed, but there would be a 25% variation in what they did. Then they basically did the same, using that same machine learning, they got bots to do it, let's call it that. They were finding ultimately that they would get in the order of a 90% variation between, so how they were doing it, 4 together and then they'd sort of 75, there were no issue, then they would talk amongst themselves, work out who was right and who was wrong, and they would get to a number. But that number was in the order of 15 to 20% lower than what they got to when they did them with the machine. So yeah, there's one way of looking at it that says, okay, machine learning was 10% wrong, but the humans were in the order of 25% wrong.
So, bearing this in mind and having shared discovery between both parties, is this changing the way litigation is going? When you remove the cognitive biases and the heuristics and all these things that have helped select information around an argument, once you've taken that human error out, is that changing the way that judgments are being found? Is it processing through the courts quicker?
Not yet.
Anchoring points are different than when you're relying on one consistent set of facts.
I think it's probably a question for the Americans. I can't comment on it because it's just not happening enough here to actually say. You know, that, as I say, that example I gave, that's just one occasion on which we've deployed this technique here, and it was for a non-Australian entity. And look, it's a really good question now, and I would imagine it would at some point. Yeah.
Well, it is. It does seem that some work is being done in large due diligence exercises in a transactional sense. But again, I can speak to transactions before I can speak to litigation always. I don't know. I have a feeling like it'll be like the mobile phone. You know, it'll be just suddenly everybody has one. Like, it's that sort of,
Yeah, I think so, and I think that's where we are. We're at the start of that kind of
thing
now.
I don't know where we are on the hockey stick.
Which is,
it's a hockey stick.
I would say it's interesting that you mentioned patent attorneys, because the ones that I work for like to, when they're reviewing and amending their patent specifications, like to have a printed copy and write on it and take the pages out and replace them with printed pages and all that sort of thing.
Yeah.
So that's
And I think there is
old school.
Yeah.
And I think it was interesting hearing you use the word emotional before, and I know you were, you were paraphrasing and putting some drama in. But I think, and I know a lot of you have an emotional connection with the piece of paper. You feel there are people who have printed out slides. Like, and to me, that's so restrictive. It's so linear. Like, I must admit, I hate working with slides because it means I have to have a conversation in pre-planned order, and that's not how my brain works, and it's actually not how most of us work. But there is something comforting. We think we read it better when it's, and look, absolutely we do read differently a piece of paper from how we screen on the, we read a screen. It doesn't make it wrong, it just means that we need to prepare what we write differently too. Sorry, Julian.
I've actually just want to follow that up with a point around education and future of young lawyers, because I think what's the impact really with this on young lawyers not going through that discovery in the future? Does that mean that, similar to mathematics, where young lawyers will forget how to do this, and what will happen in the world where they don't do it anymore?
I was about to embark on a PhD on exactly that topic. What does it act? Sorry, Julian.
No, go for what.
You know, essentially that was my kind of trigger question. Knowing that I spent years stuck in rooms doing due diligence, but actually it was boring, it was mind-numbing, I hated it, but that's how I learned how to negotiate. That's how I learned how deals were put together. I sat in the office of the partner, all this stuff is going. And then I had the very great pleasure, and I am a fangirl, of spending 48 hours with Richard Susskind earlier this year. And actually to the point of, even talking to him about supervising that PhD for me, or being one of my supervisors. And he effectively said, it's the wrong question. You're asking the wrong question. Because actually, that's how you learned to do what you're doing today. What the lawyers of the future will be doing is something different from what you do today. You know that, which I do. So they don't need, it's not useful to them to learn what you learned to do what you do today. They need to learn to do what they're going to do in the future. That's the trick. So I haven't started my PhD, if you're wondering, and I'm still just a TESCO qualified. Sorry, Mark, you were.
So does that mean that or is the inference, the discipline around getting the quality of the work output has shifted with that? So the tools you use to get there has shifted, so the discipline remains the same, effectively, it's just shifting online?
Look, I don't know what the answer is to that, but I
Good
think...
PhD topic.
Yeah. Isn't that what the lady whose name I forgot, the junior associate from Allen's was saying? She's like a subject matter expert on privacy because she had the time to look into it, whereas some of the senior associates and partners are running so many matters that they just didn't have
I
the
know
time.
this, I'm being paid by your student debt, right? I get it, but I think the nature of education is changing too. You guys, Mark just said in the break he's going to be studying till he dies, and I think actually that's the right approach. Micro-credentialing is changing. You will find that you will do at some point whatever it is that's interesting to you in the bit of the industry you're interested in. I'm particularly interested in design thinking. I've done a lot of study and experience in that particular space. It's not going to help me as a lawyer. You won't necessarily see it on my, LinkedIn profile or whatever. But over time, I think you'll be finding that there'll be micro-credentialing that means that you're going to study in a different way. I think you really need to be open to what it is that interests you and be prepared to go deep. Sorry, I'll get off my high horse.
No, not at all.
In terms of e-documents and e-discovery, do you find you're now just sending the judge like a link to a database where you can say,
Not quite.
here's all the documents that are part of this matter?
No, I wish we were.
Or do you still have to print
No.
out 5 copies for the submission?
Yeah, so that's a really good question. So this is, I've got a case on at the moment. It's a big law firm, top tier law firm. They engaged us about 3.5 years ago in a big construction litigation, and it's quite adversarial and heated, and it's going to go to court next year, Supreme Court. We set a database up 3 years ago, predominantly native electronic documents in it. So let's say there's circa 3 years worth of intellectual knowledge, legal analysis and input now resides in that database along with those documents. And those documents are cut and diced in many, many different ways across multiple discoveries that have gone on over the last 3 years. And there are witness bundles put together and hyperlinks going in all directions between the pleadings and the documents that are referred to those that are referred to in the pleadings, and all sorts of complexity in the database. It's quite a beast. However, we can also very quickly and easily, and we've begun to do this, distill that down to a court book. So only the documents that the parties are going to rely on in the hearing, which is what a court book is in essence. Again, electronically. And the output from the database is what we're probably going to end up using, which is just a Word document with blue numbers in it, which are the document IDs or document numbers. You click on the document number, it launches the document, and you can just play that way. However, I got word 9 months ago now from the senior associate I've been working with for 3 years on this case say, Jules, just letting you know, the partner and senior counsel, and I think they're mates, they don't want an electronic hearing. I said, what? You kind of have to, right? You've got tens of thousands of electronic documents. Yeah, give me a cost estimate for printing stuff out. Okay, cool. And I did. I gave them a cost estimate for, it was more than $50,000 to print out just a part of the database. Now they didn't print all of it out, and our trial is February, but they've begun to surreptitiously get us to print out what's possibly $20,000 worth of stuff to
I
date.
so hope you're charging them a carbon offset fee, by the way. Just
Yeah. It's disappointing. It's frustrating, but that's where we're at. And so to take that back to your question, part of the problem is that I think law and order, and we're not the only ones, but this part of the profession that I exist in has done a reasonable job of educating, for want of a better word, the profession as to a better, cheaper, faster way of doing things when it comes to this stuff. But then comes the and maybe you can talk about this, is the dynamics between barristers and solicitors, right? I still don't understand, in the face of logic, like in the scenario I'm painting for you now. You've got a great database that works, been underway for 3 years, and the counsel walks in at the 11th hour and goes, oh yeah, I need hard copy, print it out. And we end up making, of course, 3 copies, because one for Jim, one for senior counsel, who'll never read it, and one for court, just good luck, I don't know. And so we benefit. The end client doesn't benefit. The law firm doesn't really benefit, even though they think they do, because they're going like this with their paper. But they don't. It's just a habit that's formed over years.
Do you find there's a difference in usage kind of on a necessity basis? So like bigger firms with a larger staff, or the people, I guess the senior or partners, senior associates or whoever, who have staff at their fingertips, already larger resources, they're sticking to those old ways more than, say, a self-run one-man operation who has to kind of get on board because it's cheaper and it's faster.
It's a generalisation, but for me the answer is yes. Yeah.
I mean, I've got to say I have some strong views in this area that are not backed up by data. I think there are some cultural issues in law firms about the use of technology. And I was interested when you had your slide up earlier of the court there. Very white Anglo-Saxon male courtroom, to say the least. I think I counted, and most of them were covered, I think I counted 4 women in the room, and I didn't really obviously see anybody of colour or otherwise.
There's a woman there.
Yeah. I'm counting the grey hair behind and the 2 at the back, and I'm just guessing by the face there, I'm counting 4, and possibly at the very back, a bit hard to tell, yeah. But, and maybe this has just been my experience, that, when I was a young lawyer and I could type and use a computer and stuff like that, you would very quickly, maybe with a secretary or something like that. I think there is a reluctance amongst young lawyers to demonstrate that they can use technology because, and again, I don't have data other than anecdotal experience, that they get sort of put into a particular area, and I think that's a shame, actually, and I think that happens particularly in the big firms. One of the things that the it's actually the LIV Technology Committee is working on at the moment is the extent to which we're making recommendations about technology competence. So the way we practice law has changed significantly over the 30 years I've been doing it too. No longer do you have a secretary typing your notes anymore. People are typing themselves, but actually as a consequence, many of them don't know how to use Word properly. They're not using automatic numbering, they're not using fields, they're not thinking about the metadata, and that actually affects the quality of the product and what happens with your client. And they're using Excel like Word documents, anyway. Sorry, somebody's trying to say something.
Questions over this side.
Sorry.
I don't know who was first, sorry.
I was just going to say, I remember when I was doing my moots just last semester, and we had the topic of can we use our laptops in our moots, and then they're like, well, a lot of people fiddle around, blah, blah, blah. So I'm just trying to see, I guess, is it in practice, there's a lot of reluctance in using technology because of the end user not being able to use it effectively as they should, or as they could, and probably that goes down to
I'm sure,
actual paper.
Question, I'm sure it's just an excuse. I'm sorry, but I think it is. It reminds me of when we've been involved in electronic hearings and judges complained about the noise of a printer. Give me a break. It's just a convenient excuse for having a crack at technology, I think.
In the electronic courtroom,
Yeah.
they're not actually controlling it, are they? Someone's sitting there changing the page on everyone's screen.
Yeah, well, so you've got, the parties have an option there. They can use someone that we supply. You might recall a photo I put up of one of our guys in the hearing room. It's the so-called court operator. Or they can do it themselves, which is less common. Yeah, but you pay, of course, having our guy in the hearing room. Yeah. Yes?
Is the database that you store the documents safe from any hacks?
Yeah. As safe as any other database that's said to be secure, yes. Yeah. So
one of the things I really find amusing with this discussions about the use of technology in courts, it's one of the things that they keep going on about is secure video links. And I'm just like, it's an open courtroom. What is it about? Like, I just don't get what it is that we focus on sometimes. So, and sorry, Sarah, I'm interrupting.
But just on your question about the security of the database platform that we use, so we resell a thing called Relativity. It was developed by an American company. The security, now we don't host that in the cloud. We host that in our Ultimo data centre in Sydney, and it's alarmed and it's got SSL, it's got all sorts of other security layers wrapped around it. So as far as the available security, it's about the best you can get. Is it hack-proof? Probably not. Is anything hack-proof? No. However, it's been designed with the security, I suppose, is one of the top three things that needs to be in place in order for this thing to work effectively. To date, no mishaps, no hacks, but it's a perfectly good question and a reasonable question.
How far away do you see virtual courtrooms rather than like no physical courtroom? Because you mentioned it before, but how would that happen, do you think? Like, do they have firms would be able to just have clients there and then video link, or how does that
That's
work?
pretty much it.
Oh, okay.
So, did you see Suskin's thing at Victoria University?
I organise.
Okay, then the answer is yes. So he talked about that fairly more extensively than I've heard anyone speak about it, and he had a couple of slides that he put up that were, I think, photographs or stills of some laboratory type experimentation that he and others had done using some available technology. And it looked like everybody was actually physically present in the room together, when of course they weren't.
Yeah.
How far away is it? 20 years maybe in Australia? We've got to dismantle all these buildings and all these mindsets in Australia. That's the problem.
So Cisco have been doing a lot of work in that space, actually, and so they've been doing sort of immersive video conference. So partly it's around the way that the room is set up, so you actually feel, and it's really interesting. You do suspend disbelief very quickly, and you do. Once you get over that, can you hear me? Can you see me? Wear a funny hat, that sort of stuff. Actually, it does feel quite real.
Yeah.
It's really quite interesting how that's working. So Susskind actually was the lead author on a report to the UK government. I'll make it available on the Blackboard when I have access to it. But you can look it up. It's pretty easy to find in between. Essentially on making recommendations in relation to online courts. And so that recommendation came out only a couple of weeks before he was in Australia earlier this year. And and it's also in the context of the changing nature of the profession. So in the UK, the best known brand for a law firm now is Tesco Supermarkets. So it has the highest brand recognition. And so they're looking at the way that, particularly for consumer law, so the users of retail legal services, leases, parking fines, divorces, wills, for those people who are looking for those kind of generic legal services, actually, is it right for them to be able to, or be required to pay the kind of money when essentially lawyers, yourselves, do you want to be doing cut and paste to create standard documents? So they're looking at automating a lot of that, but also automating dispute resolution. And the recommendations to me make a lot of sense. You can juxtapose those against the work that's come out of Holland. So the small claims tribunal in Holland now is almost entirely online. So you do not actually even need to see a person. A person doesn't necessarily get involved unless the dispute goes past a certain point.
How good is that?
Yeah, it's brilliant. Sorry, all these people want to talk.
Oh, good.
Just with the virtual being what
courtroom type situations. Obviously, BMP is utilised a lot in the workplace, particularly with higher education at the moment. My only question really about that is, have they considered some of the inherent power structures that are put into a physical courtroom and how that would translate into a visual courtroom?
Yeah, there's a thesis in that too, isn't there?
I think there has been a lot of thinking about that, and it's also, and that's why I think it's worth looking at the Susskind report, because people are asking, and there's a judge from from Amsterdam who's been in Australia recently, actually, Dory Riling, I think her name is. I can certainly make those materials available, but they're also asking, well, what are those structures for? Why do we have, and look, and that's all the dispute in the last year with Marilyn Warren, our own Supreme Court, Chief Justice of the Supreme Court here, saying, okay, we're not going to wear wigs anymore. And, what is that? What is a court for? What is that element? Why do we need to have that respect? Are we resolving disputes, or are we determining disputes? How does it work? There's a philosophical question. Sorry, I think it's Mika, isn't it? Yes. Oh, I'm so going to get these names.
You mentioned, and I think we've heard earlier today as well, about the competency requirement that they've got in the States.
Yeah.
What does that mean for practitioners?
It's a really subjective thing, isn't it? For me, it's sort of, it probably reflects some of the frustration that's gone on in the US that's slowly building here and being led by clients, I think, in the US. How enforceable is it? Well, I know it's been enforced on at least one occasion. Don't ask me for the citation. I'm sorry, I can't recall. But I read it and went, oh, that's interesting, and then moved on to something else. It's a bit of a motherhood statement that talks about, and I will find it and I'll send it to you, because I know I wrote something on it last year for the Law Institute that's kind of just burying everything else now, but it talks about not so much, the idea isn't that lawyers, are technology experts. Of course, it's not about that, but I think it's often misunderstood. It's about lawyers making it their business to find out and have a working knowledge of at least who to go to get help with something. So I've got to do a discovery. It's a lot of stuff, it's electronic. Where do I start? You want to Google litigation support or electronic discovery, or it's that level of competence, which is almost really just about the willingness for a lawyer to engage their brain, to go looking, rather than for them to be driving a technology-assisted review of the type I talked about. That's up to the lawyer to be driving the decisions, but they've got to be very informed decisions. So I think the competency is talking about, make sure you are appraising yourself of the environment in which you're working in, which now involves a lot of technology in certain scenarios. Rather than lawyers now have to be technology proficient. That's too broad.
I was just thinking about the photo as well. I guess I was kind of going, does it require, almost like a retraining of, older set in their ways? Like a friend of ours was telling us the other day that in her new job, it pretty much, the partner, I think he owns the law firm, her whole job is to turn on the computer, and she's given a set of tasks that he needs written up, and when she's not in the office, he goes golfing because he doesn't know how to use the computer. So in a situation like that, what does that do for practitioners if that's a basic?
Yeah. Well, I can read you what the rule is here. So the ABA modified rule from 2009. To maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. And so, in fact, there's a Law and Technology Today podcast. Again, I'll share, I think I'll listen to it, make sure this is the one that I've heard before, but a group. And so this is actually, one of the reasons I like this particular one is it's going back, it's from March this year, the podcast, but it's going back to what that's meant since 2009, when that rule was introduced.
Imagine it would be diversifying that picture.
do wonder to what extent, and again, probably where I did start my big girl crush that I have on Richard Susskind was when, hearing him say, or, reading him write is probably better, that the law is no more there for lawyers to get rich than ill health is there for doctors to get rich. Now, and don't get me wrong, I'm a commercial lawyer. I don't deal with people at all. I deal with money, preferably large amounts of money being transferred between complete strangers. Like, I don't want to get into anybody's life. I don't want to be responsible for the outcome of somebody's access to their children or otherwise. Like, I'm out and proud transactional lawyer. But I also believe that we shouldn't have to pay more than something is worth just because there is a monopoly of a tiny number of people who have particularly outdated skills. Some really smart people do this work, and it is really challenging, rewarding work. So actually, I don't want to see you doing cut and paste and turning on an old bloke's computer for the rest of your life. I want you to be using your phenomenal cosmic powers as opposed to parking cars. And for those of you who don't get that reference, you will notice that this is Law 1042. Sorry. Hitchhiker's Guide to the Galaxy. Do I really need to subtitle that?
Just actually on the point of competency for individuals, do you foresee that the increase of eDiscovery and the use of technology in legal would actually benefit for people who actually don't use lawyers in the sense that a lot of these things, if they are particularly computer savvy, a lot of them can actually do all of these things by themselves without, especially for example in VCAT, a lot of cases don't actually require lawyers. Having the ability to use technology in the sense would help them a lot in terms of just doing their own self-defense.
Great question, and there's an example of this just last week actually. One of the directors, one of my bosses, Law and Order now, okay, so he's slightly different, but he's not a lawyer. But he's technical. He understands the workflow, and he got a hold of correspondence between he and a household name supplier of some equipment that we were using that didn't work. It was getting into dispute territory, and he did his own threading of emails and all sorts of things over, I think it was possibly in a 12-month period, so a reasonable amount of data. But he was telling me last week how he effectively did his own discovery without engaging a lawyer, just by simply being able to use email threading, some analytics, some basic analytics and keyword searching, and was able to sort of hammer out a bit of a settlement with the other side after he'd done his own work using the Relativity platform. So the answer is yes. If you have the wherewithal and the chutzpah to get up and do the self-service, then yeah, absolutely. Because a private citizen can go and ring us and we'll provide them with access to the database. They don't need to be a lawyer. Yeah. Any other questions? Yes.
If we're going to look at a cost-benefit analysis, leading on from what Mika was saying with larger top-tier firms, can you strike a figure of where your services fit into, say, the value of the matter at hand?
Yeah, we could. And I know that exercise has been done on and off over the years. As far as putting some metrics on that, I tend to sort of say as a rule of thumb, if you've got 10 folders or equivalent in hard copy or electronic copy, and there are some other contextual issues like it's an adversarial dispute that may continue on, and therefore there may be extra material produced because the scope broadens. If the quantum's kind of justifies it, or it feels like it does, I'm trying to sort of take the decision-making process, or make the decision-making process a lot easier by, I'm just simply discounting now, more aggressively than I had in my career, because I don't want lawyers, I want to take away as many barriers and excuses as possible. I know that price is sometimes a barrier, and it's hard if you've only got 5 lead range folders of documents to get your client to agree to pay $1,000 for a database, $2,000 for a database, whatever. So I try harder than I ever had in my career, because I really, really want this to change, to remove those obstacles. So I'll waive setup costs. So the standard setup cost for a relativity database that we provide is $1,500. And that's a one-off cost. And then there's a monthly hosting fee. The rack rate is $180 a month per gigabyte. And then there's a $200 per user per month fee for each user of the database. Now I've slash and burn those prices to get more lawyers using the tool.
There's for a typical matter that would say a $50,000 issue.
Yeah, I'll be more aggressive in slashing the price though, on one or two scenarios. So down one end of the spectrum is a really small litigation where it probably on the face of it doesn't make sense to use a database, but you can get value out of it anyway if you've got the appetite. In order to acclimatise lawyers to using this tool when they really do need it. So it's not so, whoa, hang on a second. And then down the other end of the spectrum is scale. So we've got 1.7 terabytes. I got a phone call about on Friday. I'll host that at $50 a gigabyte or less, as opposed to $180 a gigabyte. So that's kind of, there's a big margin in that for anyone, not just law and order, hosting gigabytes. Amazon does it for free. But I want to talk to all lawyers about all scenarios so I can understand where their head's at. And sometimes it doesn't make sense, right? I say, a couple of folders, cool. I'll do you a word list. We'll manually capture all the information from the face of the document. We'll scan it for you. We'll link it to the Word document, and then we've got a nice hyperlink list that you can send to counsel. I can put it in a secure Dropbox environment for you. You can download it and email it to them, or they can come and collect it. So low-tech solutions, and they're still technology solutions. Yeah. But there's no magical number, unfortunately. There are always a few dials that you need to turn to work out what the right frequency is. Yeah.
Do you find that most companies and law firms and stuff have a sufficient or adequate way of keeping all their electronic data at this point, or do you find that most of them are still using something that isn't as effective as it could be? Because obviously the more effective your storage mechanism is, the more people will use it, and the more easy it will be to find.
Well, it's about, the law firms are okay, by and large. It's about their clients. So their clients' information governance is the issue, and that's often poor. Yeah. Law firms, by and large, are pretty good. You might get a sole practitioner in the burbs that's all over the shop, sending emails to him, attaching confidential documents from his Yahoo account or something. You know where that's being routed, that email? Anyway, yeah. Talk about security. Yeah.
How long do you store those documents?
Okay, so when we scan documents, it's 60 days. When we're given electronic documents to print, normally 30 days, and unless we're told otherwise. Any electronic native documents, we have a process of just naming the file that the data is stored in, do not delete, and we review the do not delete list each month, and we go through and we'll ring our clients. We've had this for 12 years now, do you still want us to hang on to it? And so we
don't use the 7-year advice?
Not all the time, no. We just follow the instructions of our clients in that scenario. Yeah.
Fairly top-line question, but are you seeing any particular platforms where all the data can be homogenised and organised in a way that will be uniformly accessible across the industry?
Not yet.
I assume that's coming. It just sort of seems like, from what you told me, that would be the natural next step in disrupting this fairly clunky set of processes. But who's developing this? Because clearly the money for it, the demand, it just seems like a commercial missed opportunity.
Maybe. Well, I'm not seeing it. It's in that it's not happening. Is it a commercial opportunity? Possibly. So I reckon Google or something like that would be. I'd be looking to an organisation like that that's massively cashed up and has the scope and the influence with government and everybody else to make it happen. But yeah, go for it. I reckon you're on something there. Yeah.
It's interesting because most businesses are paperless or starting to go paperless. I'm in the workers' compensation space. If you go to say QBE or something like that, they're all paperless. Yet it's not until the legal environment that all of a sudden I have to download everything.
Yeah.
So when you talk about lever arches of files,
Mm.
business haven't got those lever arches of files until it's litigated.
Which business are we talking about?
Well, just I'm with Australian Post if you like. So if we have a person who's injured,
Yeah.
we scan medical records,
Yep.
have it all attached to the files,
Yep.
and then when it's litigated,
Yeah.
the lawyers are saying, well, you've got to download it for us.
Yeah.
We want it in hard copy, as you say, they want it in hard copy, and then
Yeah.
they do their discovery and all that sort of stuff with it. But
Yeah.
it's nearly to the point where business, if you like,
Yep.
have got it all
Mm.
on an IT platform
Mm. Mm.
that you can just, the pipeline's nearly complete.
Yeah.
For me, it's just that legal process that's not tapping in.
I part agree with you. I think that's right with, I mean, Aussie Post's got a pretty good reputation these days for being quite progressive, and I heard your CEO on ABC Radio a little while back and was transforming the business quite rapidly. Look, I don't feel comfortable saying that business generally is digital now or paperlike or whatever. I'm just not seeing it that way. I'm just not seeing it. I mean, we do work for insurance companies and banks and small businesses, medium-sized, government, large corporations, and I'm still seeing a combination of things. Even though they may have their own overarching policies and tell themselves that they're doing things a certain way that's righteous and it's digital. I don't know, as long as you can hit print on that thing, I just see same old, same old. And also, I think when it comes to discovery, people will go, oh shit, and they'll just reach for the paper that's still lying around and just give it to the compliance dudes, get it away from me, rather than go, oh okay, so I have to look through my email store from 2012 to 2015, looking for these issues, and then how do I store all that stuff to corral it away from everything else in order to give it to the blah, and I don't know. I'm just not seeing it that way. It's just still very fragmented, despite policies and law firms. I mean, I go into law firms now, they talk about, we're paper light now. How does that mean? And no one can really articulate it.
I must admit, I'm a bit with Michael here in the sense that my observation is, and I'm working essentially in three industries: education, financial services, and law. And I would say without a doubt the lawyers are more likely to have stuff on paper and keep it on paper.
No, I agree with that.
I would say my experience in business otherwise is everybody's printing everything out, but then when they're finished with it, they put it in a shred bin.
Yeah.
Like the actual records are kept online.
Yeah.
And I think there is, depending on what the thing is, I'm seeing many more people using tablets, and I think to me, it just seemed like there was more and more paper, and then as people started using tablets more, particularly for their own note-taking and stuff like that, so they've got the document and they're writing on it and they're keeping it that way.
Yep.
I'm seeing a lot less paper. So
Yeah.
I don't know. I mean, most of you are working in some sort of industry. What do you see? Seeing lots of files. I mean, you're in property, which is
We have to keep
gloriously paper, ridiculous.
A lot of stuff we have to keep in paper for records, but we try and go low paper as much as possible. But then it depends on some of the directors still keeping up with 1996 work practices, and they want us to print out everything and file it and put it with all the dust and stuff. But as they tend to retire out of the business, we go and digitise everything so that and we use optical reading. And then it's only law firms that send us a lot of documents on fax. That's it.
Wow.
So that the notice can be. Sorry.
No legal obligations to keep it.
No, the deemed notices. I mean, expiry dates and renewal dates of leases have to be served notices. So it's a function of the Retail Leases Act. So we've got to give notice, and they've got to reply in writing. So quite often that's when fax comes in. But if fax comes in as through the machine as an electronic document.
The Northern Territory and residential businesses we have to keep everything for 7 years in paper.
Oh, the leases. There are some documents that have to be kept in paper, so we digitise them and then we send them off-site. But then it's only up to them. So those kind of documents we have to. Bank guarantees we have to keep.
I've got a funny story. I used to work at the adult parole board, and we used to get obviously correspondence sent into us by email, and we would print it out to scan it and put it on the system. Can't pretend
Yeah.
why we would print it out to scan it.
Yep.
And people question why you guys let people out that shouldn't have been let out.
What's
It's just, you know, they could be unrelated.
What's the fear? Is it that they, because
Yeah.
like within our system, I can attach emails, other documents that come to me in a varied form, you know, PDFs, whatever. Even an email, I can attach it to a claim through this software that we've got. Or is the issue that the lawyers don't have that sort of software, or
No.
what's their?
No, it's because law firms for a long time they've been echo chambers, and they still are to a large degree. In that it's been easy to resist changing your day-to-day behaviour to adapt to using more technology, because no one else is doing it. No one else is really insisting that you do it. It's a bit like the billable hour. No one really, until the last few years, has started to rattle the cage on that. And so I said to a guy I know who's a managing partner of a law firm I used to work with him, when I went to that Sussex thing, I remember asking this question in April. I said, so why is it that you guys haven't embraced technology, do you think? And he said, because clients haven't told us to until the last few years. So it's with the clients, I think that one of the root causes is clients not driving the change, and now that's completely changed, and clients are driving the change far more than they ever used to. There just hasn't been an imperative. So law firm partners who are my age, I'm 48, gee, they've had it good. You know, big law firm partners, and some of them are mates, and they're with Minna Ellison with me working in the bar room when I was studying one thing and they were studying law. You know, they got rich off this thing, and I don't really sort of see the need to change.
Another Suskin quote, really hard to tell people who are making £1 million a year that they need to change.
Well, for them, it's an on-cost they just push back down the pipeline. So for them to print out $50,000 worth of documents,
charge the client.
They don't care, they charge the client.
Yeah.
It's not until, as you said, the client says, hang on a minute, guys, giving it to you in electronic form, I'm not paying the bill.
Or offshore your contract review work, or I'm taking it to these guys who say that they do, and it'll cost me $30 an hour as opposed to $300 an hour. So that's the sort of thing that's been happening the last 10-ish years.
I think some lawyers in big firms do want to be as, liked as they can. As I was saying, that we have the lawyer who's doing discovery, and he's like, if I had discovery, I'd need 6 offices, whereas I've got it all here on my iPad, sort of thing. But it also requires on the law firm having the right systems and abilities, and often the IT people are saying, oh, you can't do that because it doesn't work properly with the system, and you're like, well, fix the system. But it's a lot of that, you know, is it the law firm, is it the IT people in the law firm, is it the, well, then our precedents won't work properly and stuff with it, and you're like, don't care what it is, but maybe let's look at fixing it.
Yeah. Probably sounds a bit glib, but there hasn't been enough change because there hasn't been enough leadership, you know, in the law. Be it in the Law Institute, the profession, you know, among practitioners, among law firm managers, the leadership's started to come from their client base, who've said, change the way you do this, or I will stop paying you.
Well, in the last year, an organisation out of the States called Clock